Hello everyone, good evening and welcome to our event on this wonderfully blustery day. This event has been kindly hosted by BID in conjunction with Allen and Overy, so I'd like to take this opportunity to thank them for their help as well. Today's event is going to be, as you can see, called Access to Justice Illusion, Accessing Legal Aid for Immigration Cases. We will have four speakers, including myself, and I'd like to take this opportunity to introduce me. So my name is Tahaba Al-Hussein. I am, according to my bio, an award-winning journalist, and I really like the sound of that, so let's go with it. I spent many years working at places like the BBC, Sky, ITV News, where I accrued a number of skills because I'm actually a lot older than I look. And now I am working as an independent journalist, focusing on my subject areas, which include politics, social affairs, immigration, class, mental health, and identity. The reason why I'm working with BID and I'm so passionate about some of the key issues that we'll be discussing today is because of my own personal history. I came to the UK age 10 after my family fled the Somali civil war, and we moved to the UK by secondary migration from the Netherlands. I myself was actually born in a detention centre in the Netherlands where I spent my first 4 years, after which I moved to the UK age 10. At age 18, I was fortunate enough to have been granted a scholarship to go to university. And then upon graduating, I started off my career as a journalist. I didn't have any issues being a Dutch national in the UK in the wonderful years post the dreaded B word. Once Brexit hit, of course, as you all know, everything changed and I needed to apply for my EU settled status. At the time, I was actually working as a political reporter for the BBC covering Brexit extensively. And it was I who first broke the story. I don't know if you guys remember, way back when in the days when you actually had to pay the application fee to apply for your EU settled status. And back in the day when the EU Exit ID app was only available on Android and not iOS. Following a couple of years later and following a few more bylines covering the EUSS scheme, I encountered my own issues. And some of you now may realize that I look familiar. And that's because I became my very own case study when I, unfortunately, lost my indefinite leave to remain in the UK and was very nearly deported following losing my rights to live after I think it was 3 applications later because of there being not enough evidence that I was in the UK. One of those times was when I was studying at the University of Cambridge in 2015. Second one of those times was when I was working at the BBC. And the third time was during the pandemic when I was at home running couch to 5K and playing bingo with my mum. It's not sure where, and then after all that was sorted, actually became what I like to call my villain origin story, was when I decided that actually I would like to use my powers for good, and I'd like to use all the skills that I accrued in my journalism career thus far into highlighting underrepresented issues and amplifying the voices of people who need it most, because I'm aware that I myself was very fortunate. I was able to use my profile, I was able to use my connections. I had the head and founder of the Warehouse Project offering to pay for all my legal fees. I had national newspapers covering my story. And luckily, I managed to get my issues sorted within 3 days. But I know for people who much less know their rights and aren't able to articulate them, it is a very different landscape out there, which is why I'm so pleased to be hosting this event with all of you here today. So let's get started. I would like to start off with introductions from our wonderful panel. Carmen, please do tell us more about yourself.
Oh, hello, I'm Carmen. I'm legal manager of the ADAP Article 8 Deportation Advice Project at BID, and we do applications to revoke deportation orders, human rights applications based on length of residence or family life in the UK. We provide representation to people at the early stages of deportation if they get a letter from the Home Office saying we're planning to deport you and ask for reasons why they shouldn't be deported. We assist on those areas, and I work on deportation appeals. And on applications of exceptional funding legal aid, which is what I'm going to talk to you about in my talk.
Rakesh, please do tell us a bit more about yourself.
Good evening, everyone. My name is Rakesh Singh. I'm a solicitor at the Public Law Project, which is an access to justice charity. Some of our focus areas include immigration and also legal aid. So I'm delighted to be invited to speak here this evening by BID.
And finally, Brian, take to the stage.
Hi, everyone. Thanks so much for having me here. I'm Brian. I'm the legal organizer at a charity called Migrants Organize. So I'm an RC Level 3 immigration and welfare advisor, and I coordinate our project, which provides holistic support assistance for migrants who lack mental capacity to engage in the immigration system. And I also lead on the charity's strategic legal and policy work, including on legal aid.
Brilliant. Well, as you can see, we all have a very impressive panel. And firstly, we have Carmen talking us through her presentation today.
Thank you. Thank you. Right. Good evening. So I want to talk to you about BID's particular experiences of the legal aid landscape in two key areas we work on: the Exceptional Funding Project, KSOP project, and our annual legal advice surveys of immigration advice in detention estate, in immigration removal centres and prisons. And I think we have a unique insight, I think, into the impact of the lack of legal aid, access to justice, for one of the most vulnerable client groups. Briefly, first of all, for the lay people in the audience who are not familiar with deportation law, just a bit of background. So what LASPO, which is the Legal Aid Sentencing Punishment Offenders Act, introduced in 2013, I think, was remove challenges to deportation based on length of residence in the UK and or family life from mainstream legal aid. So an individual who wants to challenge deportation on those grounds would have to either pay privately or obtain exceptional legal aid case funding. And the exceptional funding was supposed to be a safety net that individuals could apply for if they could show that they wouldn't have access to justice without a lawyer. They couldn't represent themselves fairly. And the applications, just so people are aware how it works, you can make an application for legal aid exceptional funding without a lawyer. But if it's granted, you have to find a legal aid lawyer to represent you. But also the lawyer, if a lawyer does make an application for exceptional funding, they don't get paid for that application unless that's granted. So I'll explain later on, that could be quite significant in terms of whether or not lawyers will actually make the applications for exceptional funding for people. Just to gain more context, why representation is important in deportation cases. Obviously, just as a starting point, if someone's deported, they could be permanently separated from their family in the UK, including minor children. So the implications are huge. But a number of reasons why having lawyers is so critical. The first one is that immigration rules are extremely complex. I have my slides. Oh, sorry. Yeah, sorry, I've lost my slides. Right, yes. So immigration rules are extremely complex and constantly evolving, and the courts are constantly issuing new guidance on the meaning of key terms used in immigration rules, such as the meaning of unduly harsh when looking at the impact of deportation of a parent on a child, and meaning of very significant obstacles to reintegration of an individual who's perhaps lived in the UK for a very long time, maybe nearly all their lives, and is looking at being sent back to the protected country for deportation. And realistically, it's unreasonable to expect an individual to be able to understand the meaning of these terms and apply them to the facts of the case without a lawyer. Another reason why legal aid is so critical is that expert evidences can be really important in whether a case succeeds. We frequently, in our cases, need usually more than one expert report in cases. The most often required, the ones most often need would be risk of reoffending reports from forensic psychologists, a best interest of children report from a social worker to look at the impact on the child of deportation of a parent or primary carer. That's really critical if there's children involved. And often mental health reports could be the parent or the child or the partner. But these reports are extremely expensive. They average about £2,000 each. So even if an individual could apply, could pay for a lawyer privately, it's very unlikely they're going to be able to pay for these expert reports, which can be so critical to the outcome of the case. So our ECF project, exceptional funding project. So we at BID, we do applications of exceptional funding. I do them as part of ADAP, but we also work with 4 commercial firms on our exceptional funding case project, pro bono project. They prepare applications for exceptional funding, and if successful, we refer to legal aid lawyer. And at that project, I won the best new pro bono activity in law works in 2019, which we're really proud of, and we're still going. We've just produced a report on our findings of this, of the evidence we produced from our applications, called Hurdle After Hurdle, Struggle for Advice and Representation Through Exceptional Funding. It's on our website, and I won't go through in detail now, but I'd great if we could read that, because we've got lots of case studies in it, and it really explains some of the kind of obstacles and what they mean with people on a day-to-day, on-the-ground basis. So just some very key findings from our report. The first one is that the application process for exceptional funding is extremely complex, and it's really hard for a layperson to do it without a lawyer. The forms are long and complex, and they require a lot of details to why you can't represent yourself, why your case is complex, what expert evidence you might need. And really people just see these big, thick forms, they're intimidating, and they don't really know how to approach it. So often people just won't make an application themselves. The second key problem is that once legal aid is granted, and we found we get them granted because we make quite strong applications, but finding a lawyer is a really an uphill struggle, and that's really the main barrier for us. On average, it's taken 1 to 2 months to find a lawyer, but in a number of cases, it's much longer than that. We've had cases taking 6 or 9 months. We're phoning at least 50 lawyers per case, in many cases, not all cases, in many cases. In one case, we phoned 130 lawyers, and we're still, we're struggling, and that's extremely time-consuming for a small organisation trying to plug the gaps. And in one case, we had an extremely vulnerable client who was at appeal stage. The courts had adjourned. We got funding. The courts had adjourned a number of times to allow us time to find a lawyer, but got to a stage where they're saying, "Look, we're going to have to hear this case, even though we acknowledge that the client, is probably going to struggle on their own, and they've got a grant of funding, because we can't keep adjourning." And we actually had to approach the legal aid agency itself directly and say, "Look, we're in this position. We really need some help to find a lawyer." They did step in, and we found a lawyer, but clearly that's like a one-off, drop in the ocean. It doesn't address the structural problems. But it goes to show how serious the situation can be, particularly if you've got a court hearing coming up and you can't find a lawyer. Also, we found we were trying to plug the gaps between when somebody is granted legal aid and hasn't yet found a lawyer, haven't yet referred out. The problem is that the system doesn't stop. The Home Office keeps making decisions, the courts keep listing cases, sending out written directions as to what has to happen in appeal. And we find ourselves having to help the clients in making applications to adjourn, explaining what directions from the court mean, what's got to be done when, what evidence has to be submitted and when. Applications to extend deadlines, all work which should be done by a legal aid lawyer because the person at this stage has been granted legal aid, but we're having to step in and plug the gaps. Just some of our key recommendations from the report. We recommend that all immigration cases be brought back into scope for mainstream legal aid, so you don't have to apply for exceptional funding. But if this, as long as exceptional funding and LASPO remains in force, it's clear from our policy, our casework evidence, that the system needs to be streamlined so that somebody can make an application themselves confidently and have a reasonable prospect of getting that funding without a lawyer. The third thing is clearly legal aid lawyers need to be paid for the work they do. They should be paid for making the application, even if it's not granted. And they should be paid adequately and fairly for legal aid work and cases they take on. And that's certainly part of the problem, is the levels of legal aid payment. But I would encourage people to read the report because there's much more detail on the case studies, and I think it's interesting reading. So moving on briefly to biz legal advice surveys. This is an area I think that we do have a unique insight, because since 2010, we've been carrying out surveys of access to legal advice in removal centres and in the prison detention estate. So people who can be held under immigration powers in both removal centres and in prisons. And it gives us a snapshot of what's, trends, basically, what's been happening. All of our reports are on our website. So again, I'd encourage people to have a look at those. But for people who are not aware of how the system works, in removal centres, there's a duty advice scheme, and somebody can get 30 minutes access to advice with a solicitor. And if there's enough merits in the case, that case should be taken on. which sounds very good in theory, but in practice, we found that it's simply not functioning effectively. It's not providing the access to justice that people need. In November 2012, before LASPO came into effect, 79% of respondents had a lawyer, 75% were legal aided. On May 13, just after LASPO came into effect, under a third of respondents had a legal aid lawyer. So that's a massive, massive cut. And these are people, don't forget, in removal, in immigration detention, potentially facing removal from the UK as well. So pretty desperate circumstances. Since then, the number of respondents with a lawyer has frequently fallen below 50%. Also, there are problems with it functioning in terms of long waiting times to access the duty advice desk. Solicitors not taking cases on after 13 minutes, solicitors asking people to pay a fee rather than applying for exceptional case funding. And these problems have persisted all the way through. Our most recent survey, I think the 2023, which is on the website, and you can see these problems have persisted. So there's clearly a problem with access to justice. Just briefly, in detention, people held in immigration and detention and in the prisons, there's no DDA equivalent, but people can access telephone advice from legal advice scheme, which was set up only fairly recently following a key case of SM and Lord Chancellor bid intervening in the High Court. And basically, this is really important because it was through bids, our policy work helped to show the discrimination between people in the removal centres getting access to legal advice and people in immigration detention and prisons who weren't getting the same access. There's discrimination there. But it was a good example of our policy work and our evidence leading to litigation and positive outcome and access to justice. And that's something that we will continue to work on. The Illegal Migration Act, we don't know where we are with that, but assuming it does come into effect in some way, shape or form, what we know we can expect is massive cuts to access to justice and judicial supervision. In terms of legal aid, the Home Office have said we're going to give a 50% uplift to lawyers at work on that. But the problem with that is, first of all, whether that uplift will mean lawyers move away from other areas of access to human rights work to focus on that. But also, will there be enough? In our experience is that just the lawyers aren't out there. So this uplift is okay, having an uplift, but if the lawyers aren't there to take up that work, then the access to justice is clearly going to be a problem. So just moving forward briefly, BID will continue to work to improve access to justice via our legal aid exceptional funding applications project. And in that, I mean, as I say, it's both getting access to justice for individuals, but actually gathering policy data, which is what our report did as well, to try and really gather information, which we may be able to use for policy work for strategic litigation. With the overall aim is to try and get legal aid or immigration deportation cases put back into scope to avoid this whole ECF process. That's our ultimate goal. So we will continue with that, despite the differences I've mentioned of finding lawyers, trying to plug the gaps and the time that takes for us. Research work, policy and lobbying, using the data we gather, and I say strategic litigation, which may well be the way forward in terms of dealing with a case, which is a systemic problem. It's not, individual applications are not enough. There's problems, it's clearly not working. There's a systemic problem with the legal aid system. And the battle ahead is going to be particularly, if the IMA comes into effect, it's probably going to be one of the most significant battles that we're going to face as a sector in terms of a kind of perfect storm of lack of access to justice, lack of lawyers, and potential massive breaches of human rights if this comes to effect. So I'm hoping that you're all going to, well, you're here tonight, so you're obviously concerned, you'll read the reports and you'll support us and continue to support us in this battle, which is going to be, our future in 2024. And on that note, I'll end. Thank you.
Thank you, Carmen. As Carmen said, all of BID's reports are available on the website. I have actually read the ECF report and unfortunately had to deal with one of my case studies who was facing deportation really recently. And so I can attest to how laborious and difficult the process is and how much invaluable work BID are doing currently. Next, we have Michael, who is a former client and current campaigner with BID. Michael is speaking anonymously under the pseudonym of Michael. His segment of the talk will be in a Q&A format between myself and him. So, Michael, are you there?
Yes, I'm here. Can you hear me?
Yes, I can indeed. Can you hear us, or me rather?
Yes, I can hear you.
Brilliant. So firstly, Michael, could you take this moment to introduce yourself and tell us a little bit more about you?
Yes, my name is Michael, and I've lived in the UK for the past 30 years, basically all my life since I was a child. Unfortunately, I got myself involved into some situations that 2 years ago, which I served a prison sentence. And as a result of that prison sentence, because it was over a certain amount of time, over 12 months, I was issued with a deportation order, and it's still ongoing. My whole family lives in the UK. I have a child that lives in the UK, and at the moment, these are the issues that I'm going through.
We'll hear more about Michael's really compelling story as we go through the questions here. I guess the first question that I'm really interested to ask you is about the title of this event, Access to Justice or Just an Illusion. This came from one of your statements. Can you elaborate on what you meant by that?
Yes, at the time when I was in prison, I was trying to contact immigration lawyers to support me with my case. And I called over 30 immigration lawyers, and all of them always told me the same thing. They didn't have the capacity to deal with my case. And eventually I got in contact with BID, which helped me with my application for bail at the time. And furthermore, they put in an application for me for legal aid, which was granted. And since then, they have also called numerous of solicitors. I think it was probably like 40 solicitors. And in all, with me calling them, with BID calling them, that's over like 70 solicitors that we've called in together. And I still haven't got legal aid solicitor to help me. So that's why I said, is this actually access to justice or just an illusion? They give you the legal aid grant, but at the same time you can't find legal aid solicitors. So I just don't understand how it works.
Well, you speak very eloquently and your experience sounds truly harrowing. Speaking on your experience, before this event, I read an opinion piece that you wrote for The Independent, where you spoke eloquently again about arriving to the UK as a baby. When you came to the UK as a baby and have lived here your whole life, as you say, you have family here, you have children here, have you ever considered yourself to be a foreign national in your own self-identity? And when did you realize that you were being classed as one? And how did that consequently make you feel?
I've never classified myself as a foreigner, as I say. I grew up here. I started school here. My first language is English, and I've built my whole foundation here. So the only time I felt like this is when I was in prison, and when it came to me being released from prison, then I was just deemed as like, basically I've only been here for like 1 month or something like that, because I've been here for so long. I thought maybe the process would have been different for someone that has been in this country for so long, but when it came to it, I've just got treated like I've never been here before. So that's when I just realized, hold on, like literally just because I don't have a British passport, I've been treated this way.
It does sound like it's double punishment. And one final question, what would you say to someone going through the same thing? And what would you like to say to our audience tonight?
Someone that's going through the same thing, I'll just tell them just to be resilient, don't give up, keep pushing. If you've come to the UK not illegally and you went through the proper processes of entering the UK, then you have rights to be in the UK. So I would just say to them not to give up and keep pushing, and hopefully that you'll get you'll get what you deserve, and that's being able to stay in the country that you've made home. And also for my audience, I'll just say to look into this more and see actually what the system is doing to individuals, because you won't know if you're not going through this situation. I never knew this is what happens to people until myself has been in this situation. So just take the time to understand these things, and I feel like together we can all work to change this, and everybody gets a fair access to justice and a fair trial, and don't have to go through what I'm going through at the moment.
Thank you, Michael. Thank you for sharing your story with us.
Yes, thank you.
And next we have Rakesh.
I'm going to stand because I've been sitting at a desk all day, so I hope you don't mind. Oh, thank you. So just warning you, my slides are slightly blinding because they're on a white background. Right. So access to justice, is it just an illusion? And I think that, thank you, Michael, for sharing his story with us, because his experience, because I think that just shows that access to justice is not an abstract concept. It has a real impact on individuals and their families. And particularly in the context of immigration, where fundamental rights are at stake, so people can be separated from their families, they can be returned to places where their safety is at risk, it is absolutely critical that people have access to lawyers and access to the court. So I thought that's perhaps where we could start from. I'm speaking to you as a lawyer from a charity where we try to support access to justice. So access to justice, the right to access to justice, it's what's known as a constitutional common law, that's a judge-made law, right. And what it means, it's a trilogy of rights. So it means access to legal advice under seal of confidentiality, so the ability to confidentially communicate with a legal advisor, and crucially, access to the court. And any restriction on this right must be expressly authorised by Parliament. So it can't be restricted by the executive. The Home Office or the Legal Aid Agency or any other public body can't just make up a rule or try to interfere or restrict it. And so why is it important? I mean, I think it's obvious from some of the examples we've heard, but also it's inherent in the rule of law. So the courts apply and enforce Parliament's law. Parliament is the will of the democratically elected MPs. You know, we hear a lot about the will of the people. Well, our laws are the will of the people. They are those which are passed by Parliament. And it's then for the courts to enforce the Parliament's laws and judge-made law, the common law, and ensure that the executive, so the Home Office, the MOJ, any other public body, acts in accordance with it. And people must have access to the court, or the law can't be enforced. Parliament's will can't be enforced, and laws become meaningless. Okay, so that's kind of the, sort of the principles overarching approach, but you can understand why it's important in individual cases. So we talk about a right, and in terms of what the courts will consider as to whether or not that right is being breached, the question the court will consider is whether there is a real risk that the executive action in question has effectively prevented people from bringing claims and therefore having access to justice. And in examining that question, the court will have regard to evidence regarding its likely impacts, and the court has to make an overall evaluative assessment whether this legal standard is met or not. So it may look at statistics, it's meant to look at the full run of cases that go through a system to see if that system, that policy, the way that the executive is exercising its power restricts the right to access to justice. So just a couple of examples. The removal windows case, this was a case that was brought by the charity Medical Justice against a Home Office policy which concerned removal. Now, I won't go into all the details, but essentially the effect of that policy was that people were at risk at removal before they could have access to the court. That was because they weren't told the date and time of when they would be removed. The Home Office would make decisions on their case to refuse them permission to stay, and they wouldn't have the ability to see a lawyer or go to court. So that's an example. In that case, the Court of Appeal decided that the policy restricted access to justice and said that the policy was unlawful. Another example, Carmen was talking about ECF forms and how they're really complex. Well, when ECF was first introduced, there was a judgment in the case of S against the Director of Legal Aid Casework, in which PLP was involved. And the court found that the forms were too complex, just as they are now, in fact, but at that time they were too complex, and they were acting as a barrier for individuals to access ECF. So it unfairly impeded access to legal aid, and so access to justice. In that particular case, though, because the legal aid agency were actually taking steps to try to improve the forms, the court found that that was enough, and so didn't find that the LAA, the legal aid agency, had acted unlawfully. Now, more in the context of detention, people in detention, and the work that BID does, so I'm just going to talk a little bit about the detained duty advice scheme. So Carmen mentioned this in her talk. The DDAS, the DDAS, is the primary way for people in detention in immigration removal centres of getting access to justice in detention. And a case was brought by the charity Detention Action in which they challenged the way that the Lord Chancellor was operating the detained duty advice scheme, basically saying that it was the way that it was being operated was in breach of access to justice. And that was because firms in the scheme weren't taking on cases from the people who attended the surgeries. Under the contract, firms had to advise people about bail and take on bail cases, but they weren't doing so. And this is what the LAA's own evidence seems to be showing. And also there were incompetent firms. There were firms that had been peer reviewed by the LAA's own legal aid agency's own peer reviewers, and they were found not to be competent, but they remained on the surgery rotas, or they weren't actually allowed, or they weren't able to do judicial reviews, which is a key remedy for anyone who's in detention, because that's how you challenge removal. So that was the case. In its judgment, in the court's judgment, they said that it is possible that the operation of the scheme could breach access to justice. So the scheme like the DDA could breach access to justice. And also the Lord Chancellor's duty under LASPO, the Legal Aid and Sentencing and Punishment of Offenders Act, duty to secure legal aid is made available. And examples of how the right of access to justice might be restricted would be if, for example, the judge gave a couple of sort of extreme examples, but say, for example, the Lord Chancellor introduced measures that could dissuade providers from taking on work, such as setting payment rates too low, excessive regulation, so firms having to have unreasonable administrative burdens and regulatory burdens. So those are some examples. But in the case of the DDAS, the court decided that it wasn't persuaded on the evidence. Now, that was in spite of the fact that a number of NGOs, BID included, who worked in partnership and supported this application, and their legal advice survey actually was a key part of the evidence. It gave an insight as to what was happening and the fact that people couldn't access representation. So we had that. We also had, sorry, as the solicitor acting in this case for detention action, we also had the LAA's own evidence, which seemed to show that there were some firms that just taking on no cases at all. People would attend their surgeries. They hadn't taken a single case on, but still that wasn't enough for the court, because there was, when we got into the more granular analysis, there was enough to kind of muddy the waters. And so the judge found it didn't meet the high threshold. So that's a bit about access to justice in the context of detention. But outside detention, in the community, individuals also have problems in accessing legal aid. That's not just accessing exceptional case funding, which has been taken out of scope, but also in-scope legal advice. So asylum claims, protection claims, things which are funded. And the reasons for that, there's been a lot of literature on this, a lot of research. It includes lack of, essentially there's a lack of providers, there's a lack of provision, a lack of firms, particularly in certain areas. One of the reasons is that legal aid has been, sections of legal aid have been taken out of scope. And as you heard from Carmen, exceptional case funding is really complex, so that remains a barrier. Secondly, there's the complexity of legal aid itself and regulation. It makes it really difficult for funders to navigate all of that. Thirdly, there's the complexity of immigration law. I mean, there are so many policies, there are so many things that you can't appeal against. From my personal experience as someone who is still an immigration law practitioner, is that I will often have to open numerous matters for a client because there are so many issues that arise on their case, so many legal issues for which they require advice. So it's extremely complex. But I think the key thing is it's financially unsustainable. So firms aren't going to do the work because the rates don't cover their costs. That is really the key problem. So what can you do about that? So what is the legal test? Do these legal aid advice deserts breach access to justice and the Lord Chancellor's duty? Now, I think some of the key areas that need to be considered, as I said initially, is there a real risk that persons will effectively be prevented from having access to justice? That's one. Two, is there evidence of serious unmet need? And I think, there's quite a lot of research, there's a lot of publications which would indicate that. And I think that NGOs who have contacts with like BID, but others who assist people who are not detained, will tell you that there's a real problem with trying to find an immigration solicitor, and that's what Michael said as well. But crucially, is there evidence that access to legal aid is delayed or unavailable to the detriment of those needing it? And that is often where the dispute is with the Lord Chancellor and the MOJ about whether or not there is actually access to justice. And that's really where the question before the court is focused. So how to address the problem? I mean, Carmen, I think mentioned this in her, how to move forward. And the key is evidence, and I think that many NGOs, Brian, who's been involved in chairing, coordinating legal aid organising, there's a coalition of NGOs who've been brought together who are trying to investigate and evidence this problem, and that is really key. And also trying to get as much information, FOIAs, so Freedom of Information Act requests, and disclosure The problem is, for all of us, there's so much going on in our sector. I mean, capacity is really stretched, and there's, you know, a real question of being able to resource it. So, you know, we have to be organised, but also we need funding, we need funders, we need the generosity of, you know, places like Allen & Overy, so that we can have these events and we can speak to each other so that we can move forward. And then litigation. Then if there's a problem and if we have the evidence, hopefully we will be in the position, we will have the right, you know, we will have the examples, and we will have the legal team to bring a really strong case and to litigate as a remedy of last resort. So thank you, and I don't know if these slides will be circulated, but feel free to get in touch if you have any questions.
And finally, we have Brian.
Right. Thanks so much, everyone. I thought this evening I'm just going to talk a bit more about Migrants Organized kind of experience around access to justice, and also the work that we've been doing with a lot of other organizations and charities across the country, which Rakesh hinted on just now. So as I said in my introduction, at Migrants Organized, under our community program, we provide ongoing and holistic support and advice and support for vulnerable migrants and asylum seekers, primarily in Greater London area. So we're always level 3. We can provide immigration advice, but we usually focus more on kind of the other issues that arise when it comes to asylum seekers and migrants, like destitution, asylum support, housing. You know, there's an endless list. And we try to kind of, so usually when we have a new case, we triage the case, we sort it out the ECF if needed, for example, and then we work with an immigration barrister as well, provide initial advice and case strategy, and then we try our best to refer to a solicitor, with the idea being that then we focus on the surrounding issues while the solicitor can focus on the immigration case. Now, that model worked for a while, but then it becomes like increasingly difficult. So in between April to December 2022, we actually gathered the data in terms of success rate in referring cases to a solicitor, a legal aid solicitor. Would anyone like to hazard a guess of what our success rate was? Sorry? Oh, no, that's too high. Let me know. It was 0.028%. So yeah, so it made me question, but like how well I'm doing my job. But luckily, it was not just us. So I'm a trustee for Haringey Migrant Support Center, for example, and their success rate around the same period was 3%. So it's all kind of, you know, one digit essentially, which means the answer to the question, access to justice or legislation, is the latter. So what can we do about it? I think that's kind of the big question. I think relying on the current government to do anything about it is not going to happen. What about Labour, for example, especially with the current general election looming? I know a lot of people have had kind of conversations with Labour candidates and those in shadow cabinet, for example, and immediately their response is that for legal aid, we know it's an important issue, of course, but there's just no money for it. We can't have any more budget on this issue. That's kind of immediately their response. And I don't know about you, but I feel like when politicians say that there's no money, I just don't believe it. I worked against the Bibi barge last year, for example, where the government provided 1.6 billion to one of the service provider, CTM. Now, it seems like a lot of money to me, 1.6 billion. I think it would help a lot if that kind of resources, for example, is channeled towards legal aid or other important public services like the NHS, for example. But I think the problem is that there's just no political willingness and awareness of how important access to justice is at the moment. So I think in this context, what we need to do is actually rely on each other to organize. And I think that's kind of a bit of a silver lining when there's a crisis like this. It is actually a good opportunity for people to come together, to connect and actually do something together, whether it's in the short term or medium term or the long term. And events like this are really great, basically, because it allows us to do exactly that, come together, learn about the issue and connect with each other and think about the different things that we can do. And that's precisely what Migrants Organized, and about, I think at the moment there's maybe 80 other organizations, including PLP and BID, JCWI and a lot others and across the country and Wales as well. We've been organizing around this issue for the past 12, 13 months. So we meet up every 6 to 8 weeks to, again, share issues and information, but also to kind of take actions together. And it's been really impressive and encouraging, actually, to see the amount of things that have come out of the group. So we had like a big drive to support PLP's strategic litigation, for example, getting frontline charities and organizations to provide evidence to the important work that PLP is doing. There's trauma-informed training, for example, that certain members of the group have been planning because, as you know, given that there's a crisis with legal aid, a lot of junior practitioners don't get the support that they need to actually learn how to do the job, which means then there's a lot of people going out of the sector and the supply kind of decreases. There's research project into the downward course of legal aid, and there's like a lot of these different things that I think in isolation will not kind of solve the problem. And to be honest, I don't think there's just one single answer to the issue because how complex it is. You know, if tomorrow the government decides to kind of fund legal aid in full, there are still a lot of barriers to justice that migrants and asylum seekers face, detention being, you know, one key one. So it's not just about LASPO and legal aid, it's the wider hostile environment being at play. But I think if there is kind of, you know, even if we don't achieve anything, if we come out of this as a stronger sector, that in itself is already a win. And that's what I would encourage everyone here today to kind of do, actually get in touch with me or my colleague Francis is there, or any other of the group who I can see some of you guys here as well, and join us and kind of, you know, let's do something together around this.
Well, thank you all for your very engaging and compelling presentations. We're going to open up to the room now for any questions directed to any of our speakers, including Michael, who I think is still on the line. So yes, and I think we have a mic here somewhere as well that will be floating around. So yes, over there. Oh.
If we would like to do work experience with you guys, then what's the criteria to take the SQE students or any upcoming legal career students? Or
Is that directed for bid?
Yeah.
I think I'm not best placed to answer that. I think it might be to my. I think it was a question about how someone can actually get involved in BID's work and work volunteering with BID. Is that correct? Yeah.
Oh gosh. Maybe speak to us afterwards, but you can always apply. I mean, we have volunteering positions that come up. On something like this, on this issue about access to advice, it would really depend on whether or not we're going to be setting up projects and would need help to forward those projects. But in terms of casework volunteering, etc., then that's a separate issue. Online, we have a way of applying, and we'd welcome applications, to be honest. But you know, the application process comes and goes in terms of our need, and it depends on availability of positions. Anyone can apply who wants to train up to become a lawyer. Yeah.
I just wanted to let everyone know that there's a stand out there, and it will be people from BID will be on the stand afterwards, and you can come and ask any questions, find out how you can get involved. It would be brilliant to have all of you on board with this. So thank you very much.
Hello, my name is Yasmin from JCWI. Thank you. This has been such a base comment on the compelling evidence. The testimonies we've heard has been so insightful. There's a saying that every system is perfectly designed to deliver the outcomes intended. And so all the structural issues that you've talked about, Rakesh, and Brian, that you've talked about, were about capacity, about sustainability, about just fatigue and frustration in the system. And we have my talented team here who can speak to their everyday experience of dealing with this. particularly with people in crisis. But I want to ask really kind of your perspective on, as a sector, absolutely strengthening us as a movement, but of the evidence that we collect that it is so compelling, where's the tipping point for that? How much evidence do we need to be able to say we have this? And then what's the route for that? Because especially in this consequential year ahead of us, what is it that we put out where telling us that there isn't funding isn't really attainable? It's not an acceptable response for us. So what do we do with that? One, in terms of galvanizing as a sector, absolutely, Brian. But two, Rakesh, to your point about those things that we go through, what can we do to structurally change something?
Okay. Yeah, I can. I mean, I think for me, it's more about like who's listening and who's the audience. Because for kind of, I think the evidence of the issue is already there. For example, like Jo Wilding, if anyone's interested in this issue, Google Jo Wilding. She's a barrister and a researcher at Sussex University, who's done like loads of things and produces really incredible reports on this specific issue. So I think the evidence is there to show that there is a problem, and the fact that legal aid rates hasn't increased since '96, for example, I don't think it takes like a genius to figure out that there is a problem. But in terms of politicians, for example, I think it's not about the data specifically. It's about kind of building those relationships and making them understand why it's important, this issue, why access to justice is important, and then the data for me can come after. That's kind of my analysis of it anyway. But...
All right, my turn. Yeah, I think it's a difficult question, isn't it? Because what is the tipping point? I think you have to, certainly, if you look at Jo Wilding, Dr. Jo Wilding's research, there have been select committees of Parliament all kind of mirroring the same thing, which is that there is unmet need. The Ministry of Justice doesn't seem to really be monitoring that properly. All they can monitor is that we have this many matter starts. So these are cases that a firm, a certain number of cases, a firm can open. And they say that reflects how many starts a firm has. And if they don't say they don't have capacity, then everything is fine. But that doesn't actually reflect what individuals are experiencing. And when they try to approach a lawyer, the difficulties that we've heard that they face. And I think there's a sort of disconnect. So, you know, and I think that's where the evidential dispute lies. You know, who is the court going to believe? I mean, they'll probably go with the public authority. They'll probably go with the legal aid agency. Now, I'm trying to get my head around the evidence at the moment. I'm actually advising a public law project about a potential challenge. And I'm not sure if I can say much more than that without my client's consent. Yeah, but you know, it is about, you also have to think about the end point. Like with any judicial review challenge, you have to think about the objective and whether litigation is the best way to get there. It's not always the answer. It can be part of a strategy. You know, so that might involve, you know, policy work as well. And I think perhaps two sides of the same coin are challenges against Home Office policies, or getting the Home Office to say, we do need lawyers to be involved here, because if lawyers aren't involved, people aren't going to get access to justice and the system can't work. The system will come grinding to a halt. And then, if you get to that point, then maybe the Home Office can put pressure on the MOJ. Maybe there will be the political will to deliver. So it might be a combination of maybe doing sort of a carefully targeted litigation on an issue where you may be able to get a declaration from the court that there is a breach of access to justice, combined with maybe some pressure from the Home Office, and you know, and maybe that finding will give civil servants in the MOJ what they need to go to their ministers to say, we have to do this. So I'm afraid I don't have a simple answer. I think the evidence is kind of there, but it's how to use it to meet our objectives, to meet, people's objectives.
I agree with what you both said. Just one thing I would say, the evidence is there, but I think there's always scope for more evidence. And I think what I've found that many organisations that do ECF applications, they don't record how much time it's taken to find lawyers and the extra work they're doing around, they've got the ECF but haven't been able to find a lawyer, all that stuff, because it's time consuming, it's admin, people are pressured, there's not, there's other work that has to be done. But I think there's more evidence that can be obtained. And I just think the more evidence we can, as a sector, gain, obtain and pool, the stronger that aspect of it's going to be. I mean, I just think there's so much more out there. I mean, our ECF report is just tiny compared to what's out there. And I think we need to really, I know it's time consuming, but focus on trying to get that data as well. The more data we have, the better.
I think we probably have time for one more question, if anyone has.
The panel have all talked about the shortage of legal aid lawyers working in immigration, and I wonder if you could address those challenges. And it's great to see that there are law students here today, but obviously there's this huge shortage in the profession. We see legal aid lawyers are getting older and young lawyers are not coming into the profession. What would you like to see change to encourage people to get involved?
Shall I answer that as an older legal aid lawyer? I think, as I said before, I think the key is really the rates, because legal aid firms they're companies, they're private practices. They have to be financially sustainable. You can't get a qualified solicitor doing certain types of work because the cost of having that solicitor at their desk or doing that work, I mean, it has a cost and legal aid doesn't cover it. And then that means, it means that a lot of actually complex work falls to more junior fee earners, more junior lawyers or paralegals. And it's kind of unsustainable because there's a lot of pressure. When you think about the consequences for individuals who are subject to immigration control, if you're representing someone in an asylum claim, someone who's really vulnerable, might be traumatized, might be a child, it's incredibly stressful. And, but if you are being asked to build things out really quickly, you have you just don't have the time to think. It's just a massive disincentive. So I think that really one of the things is we need is funding. We need also good support, I think, for junior solicitors, junior lawyers who are coming into it, as barristers as well. I'm not sure how exactly, maybe others have better answers. I think there are I think Joe Wilding, for example, has written a lot about the disincentives. I'm sure the Law Society and also the Bar Council have also had concerns. I'm not sure if I have the answer, but yeah. If anyone else wants to say.
I'd echo. I think that's the thing. I think certainly with the deportation work, which I work in, it's complex areas of law. The cases often take a lot of work, particularly if they're end stage. The parent's exhausted, you're making a fresh human rights application to revoke a deportation order. You're looking at an awful lot of work with the clients, like highly stressed. It's very, as you said, quite emotionally draining work, and you're being offered under legal aid minute amounts of money in reality. I think I agree. I mean, it just doesn't add up. It doesn't take Einstein to realize that that's clearly a problem in terms of attracting people into it.
However, it is hugely rewarding work in other ways. I would add. I mean, that's why I've been doing this for like 23 years or more. And it's because of the difference that you can make. You can use your legal skills in a way that makes things fairer for people, and I think that when you see that unfairness, that that your clients experience who are subject to immigration control and to subject to some really terrible decision making and the impact that that can have on them, then that really fires you up. You know, you feel, in spite of everything, there's the hostility of the Home Office, the hostility of the court sometimes, and also all the difficulties with working in legal aid. But that is why people still do the work.
I mean, just to add, I'm not a solicitor, I never worked at a legal aid firm, but I think there's also an element of like responsibility in the sector as well. I mean, obviously it's really difficult, and I think funding is the answer, the long-term sustainable answer, but you can also see a lot of difference between, you know, there are kind of legal aid providers out there who still provide really high quality work, for example, and they can exist. I mean, obviously you can argue how much actually they do kind of legal aid work compared to private work, for example, and then a lot of law centers are charities as well, so they get additional funding. But I think it's also kind of a business decision at some point, with certain firms prioritizing, you know, repeat cases, for example, using templates or going for the fixed fee cases. I think those are also kind of business decisions that I'm not saying it's an easy choice, and a lot of the times you might not see any other choice. But I think it is still a choice, and we need to kind of, I think as a sector, also reflect on that and see if that's actually what we want to do when we come to the sector, as Rakesh said, to actually like help people. And is that business actually achieving that, or should we do something else and kind of persist a bit more? I don't know if that makes sense, but
that brings us nicely, or rather succinctly, to the end of tonight's discussion. I would like to thank all of the speakers, including Michael, who is still on the line with us, for sharing their experiences with us, both professional and personal. As we said earlier, you can read all of the reports on BID's website and find out more about volunteering online or with some members of BID who will be at the front on the bench. And also just to thank Alan and Overy again for helping to fund this event with us. I'd like to also introduce Annie, our director, to the stage, where we will be saying our final goodbye. Who's making an entrance?
I have got precisely 2 minutes, and I am using this 2 minutes once to thank everybody, but especially to thank you, Michael, and to thank all our clients who endure the kind of violence of the state and don't even get to have legal sort of protections in many cases. But I'm here tonight to thank Maggie, because Maggie has been with BID for, we tried to work this out, we think it was 2007, thereabouts. And she's been the chair of the board for the last 3 years since I started at BID, and she has been just really absolutely fantastic. So I just wanted to thank you, Maggie, because she's stepping down. And Suan Rajkumar is our new chair, and he is fabulous too. I've been very lucky. I know I have. I have been very lucky with this board, and I just want to thank you all. So Suan is a charity lawyer at Bates Wells, and he will be leading BID from now on. So thank you very much.
That's it. Refreshments are outside, everyone.